DeWaal here, and this is the first Bridging the Weeks for 2016, covering December 21st to 31st, 2015, and today is January 4th, 2016. Good morning. Happy New Year, and welcome to this new year. Last year ended quietly at regulators worldwide. In the United States, counsel for John Corzine and the Division of Enforcement of the Commodity Futures Trading Commission traded very different views over Mr. Corzine's responsibility for the collapse of MF Global in 2011. Meanwhile, the Financial Industry Regulatory Authority sanctioned one broker-dealer $2.95 million for allegedly submitting inaccurate blue sheets and another $7.3 million for purportedly selling unregistered Microcap stocks and anti-money laundering offenses. There's not much to cover for these last 2 weeks of 2015, but we got a few articles, so let's get started. John Corzine, former Chief Executive Officer of MF Global Inc., objected to a proposed motion for summary judgment to be filed by the Division of Enforcement of the Commodity Futures Trading Commission in its lawsuit against him and Edith O'Brien related to their alleged role in the collapse of MF Global in October 2011, claiming that the CFTC, quote, grossly mischaracterizes the evidence, end of quote. The CFTC filed suit against Mr. Corzine and Ms. O'Brien, the Assistant Treasurer of MF Global at the time of the firm's collapse, as well as MF Global itself and its parent company, MF Global Holdings, in June 2013 in a federal court in New York. The firm, a CFTC-registered Futures Commission merchant prior to its collapse, filed for bankruptcy protection in October 2011 after using nearly $1 billion of customer-segregated funds to support its own proprietary positions. The CFTC charged all four defendants with failing to segregate customer funds as required by law and for misusing customer funds. In a letter to the court dated December 16, 2015, informing it of its intent to file a motion for summary judgment, the CFTC's Division of Enforcement claimed that there were, quote, undisputed facts that reveal that Corzine failed to act in good faith to prevent MF Global's segregation violations and further knowingly induced the violations, end of quote. Among other things, the CFTC alleged that, quote, Corzine knew that one policy, one that was specifically designed to protect customer funds, was ignored and or violated on multiple occasions, end of quote. Responding in a letter to the court dated December 22, 2015, Mr. Corzine argued that he, quote, never directed, authorized, or countenanced any violations of relevant law or CFTC rules by MF Global or any of its employees, end of quote. Moreover, he claimed he delegated responsibility for matters related to customer funds protection, quote, to experienced and competent personnel in the finance, treasury, compliance, and legal departments, end of quote. No date was set for hearing on this matter. All U.S. customers of MF Global were repaid all balances the FCM owed them. The Financial Industry Regulatory Authority fined Cantor Fitzgerald $6 million and required disgorgement of almost $1.3 million in commissions in connection with the firm's selling of more than 73.6 million shares of Microcap securities, allegedly without conducting adequate due diligence from March 2011 through at least September 2012. According to FINRA, during the relevant time, Joseph Ludovico, the broker who handled these transactions for the firm, effectuated the relevant transactions without considering red flags that suggested the transactions might be, quote, illegal, unregistered distributions, end of quote. In fact, a portion of the relevant sales involved shares that were neither registered with the Securities and Exchange Commission nor lawfully exempt from registration. FINRA also alleged that Cantor Fitzgerald failed adequately to supervise the relevant transactions and did not have an anti-money laundering program that adequately identified and reported suspicious transactions. FINRA claimed that, despite servicing mostly institutional clients, the firm, under the oversight of Jared Kessler, Executive Managing Director of Equity Capital Markets, began in September 2012 to service a small number of customers who liquidated large volume of Microcap securities without ensuring that the firm's existing supervisory structure would comply with applicable securities laws. Cantor Fitzgerald consented to the sanctions to resolve this matter. In addition, to resolve charges against them, Mr. Kessler agreed to pay a fine of $35,000 and be suspended as a supervisor for 3 months, while Mr. Ludovico agreed to pay a fine of $25,000 and be suspended in all capacities for 2 months. Macquarie Capital USA Inc. agreed to pay a fine of $2.95 million to the Financial Industry Regulatory Authority to resolve charges that, between 2012 and 2015, it produced to the Securities and Exchange Commission and FINRA a substantial number of so-called blue sheets that were inaccurate and did not have an adequate audit system to ensure the reliability of its blue sheet submissions. Blue sheets, by the way, refer to trade data produced on an automated basis by member firms to the SEC or FINRA upon their request. Regulators use this data for their investigations, including those related to suspicious and insider trading. According to FINRA, Macquarie's issues began in January 2012 after it developed a new system to generate blue sheet submissions following the commencement of clearing activities for its cash trading business. Errors by Macquarie included reversing buy-sell codes on allocations of certain customer trades, miscalculating the net amount of allocations on certain customer trades, and failing to provide any or complete customer information on certain transactions. Separately, Barclays Capital Inc. agreed to pay more than $10 million in restitution to customers and a fine of $3.75 million to resolve FINRA charges that it failed to comply with its suitability obligations in connection with sales of mutual funds to retail clients from January 1, 2010 through June 30th, 2015. And finally, Haitong International Futures Limited agreed to pay a fine of $90,000 to the CME Group to resolve charges that, on multiple dates between December 2012 and June 2014, the firm executed numerous transactions for a client in the E-mini Dow calendar spread that purposely self-matched. According to the findings of the relevant Chicago Board of Trade Business Conduct Committee, quote, the purpose of these transactions was to roll positions from one contract month to the next, end of quote. Haitong, a CME Group non-member firm, was also charged with not assigning unique user IDs known as Tag 50s in connection with its electronic trading. By the way, check out my discussion of Tag 50s in a compliance weeds associated with the article on Haitong in the article version of Bridging the Week on the website. Check it out. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. As I said, check it out. It also includes a review of the current popular film, The Big Short. This is Gary DeWaal. Have a great new year, and until next time, ciao.